I would like to introduce our speaker, and I'd like to read this if I may. Marcellus McRae is a partner in the Los Angeles office of Gibson, Dunn, and Crutcher. He represented 9 California public school children in the statewide education equality lawsuit called Vergara-vs-California. It was sponsored by the nonprofit organization Students Matter. This case had historic significance in that the judge hearing the case determined California's teacher tenure law was unconstitutional. The case could have implications beyond the state of California. Mr. McRae is a member of Gibson, Dunn, and Crutcher's litigation, white-collar defense and investigations, international trade, regulation, compliance, and the media and entertainment practice groups. He also writes and speaks on trial and litigation skills, white-collar criminal defense, and the role and impact of litigation in education reform and other topics. From 1995 until joining Gibson, Dunn, and Crutcher in 1998, Mr. McRae served as an assistant United States attorney with the Criminal Division, Major Fraud Section of the United States Attorney's Office in Los Angeles. While he was an assistant United States attorney, Mr. McRae investigated and prosecuted complex white-collar crimes that would be tax, securities, bankruptcy, and other business frauds, and traditional crimes that involve both jury and non-jury trial experience, with a 100% conviction rate at trial. So I heard oh and I heard ouch, so I'm not sure what that may mean. Oh and ouch, okay. Mr. McRae currently is a member of the Pacific Council on International Policy and the Board of Advocates of Human Rights First. He's on the boards of directors of Public Counsel, Friends of the Expo Center, and Big Brothers Big Sisters. He received his law degree in 1998 from Harvard University. I had an opportunity to, as we were planning this, to go on to YouTube and see Mr. McRae's final arguments before the judge. And I can't remember if it was 45 minutes or an hour, but he spoke directly to the judge without one note in front of him. It was an amazing final argument. So it's my pleasure to introduce Marcellus McRae.
I actually have a mic here. Is it now turned on? Can you guys hear me? I can easily project. I'm used to projecting. You can't hear me back there? I'll take the mic then. That's fine. Is this better? Great. First of all, I want to thank you. I was extended this invitation by the White Bear Area Chamber of Commerce, and thank you very much for having me. What I'm going to be doing today is I'm going to be talking about the case that you heard about, the Vergara case, in which I was the co-lead trial counsel. And, I was thinking about how to contextualize this discussion. And, I've had the opportunity to speak to several people here. And I think maybe the best way to look at it, at least from one perspective, is obviously there are a lot of people in this room that are very concerned and focused about the ideas about education and education reform. And what struck me as a trial lawyer when I got involved in this case is what I read sort of in public circulation and in academic treatises about education reform and students and teachers. And you saw arguments on both sides with respect to issues about tenure and dismissal and layoffs. And what I love about trials in every instance is that they really are the final moment when it's not what you say, but it's what you prove. Anybody can say anything in defense of anything or against something. But at the end of the day, if you're actually asked to put forth evidence to support what you're saying, the question is, can you or can't you do that? And if you cannot, the result is obviously that your assertions are untenable, they're not proven. And so it's the point where adjectives and adverbs don't carry the day and facts do. So in some respects, this is a way to sort of look at what happens when you actually have a trial on these issues that reach an adjudicated result based on evidence. So let me start off by introducing the 9 plaintiffs that we had in this case. These children came from various parts of California. They came from Southern California, Northern California, et cetera. Very courageous kids, some of whom testified in the trial, did a fantastic job, and obviously a great credit to them and their parents for having the resolve to participate in this case. I want to, if I can, sort of distill the case as far as these statutes to their essence and some of the arguments that we made and the arguments that actually were successful. But this is a really good way to give people sort of, again, sort of a condensed version of what we were talking about. We challenged in this case what were 5 provisions, 5 sections of the California Education Code that could be classified into 3 buckets: the tenure statute, the dismissal statutes, and the layoff statutes. I want to say at the outset that this was not an anti-teacher case, nor was it an anti-tenure case conceptually. This was actually a pro-teacher case and a pro-student case. We noted in our complaint, for instance, that there are a number of teachers in California that do a very good job as far as educating children, and that our focus were on those teachers that are grossly ineffective, those teachers that fail to achieve satisfactory gains in learning. I cannot imagine that there would be any disagreement that people that fail to do their job, particularly people that are entrusted and have stewardship over our children, should not be continued in those jobs. It's a pretty elementary concept, and it was certainly one that we can see sort of throughout some of these arguments. So with respect to the permanent employment statute, in California, it's mislabeled a 2-year statute. And the reason it's mislabeled a 2-year statute is because even though it says that it's 2 years, the time within which a school district actually has to determine whether or not a teacher is going to get tenure is on or before March 15th of the 2nd consecutive year. In order to make that decision actually has to be made, and sort of started, probably in December or January to meet that March 15th deadline, which effectively means that the amount of time within which to make that tenure decision is about 16 months. And sort of the argument that we advanced is that that is an unduly compressed period within which to make such an enormous decision as to whether or not someone's going to be given permanent employment, and that it's also a decision that was devoid of, among other things, objective evidence of learning and a sufficient basis on which to assess whether or not that person was actually effective as a teacher, to wit, whether they were actually effective at achieving learning gains. And that when you have such an unduly compressed period, inexorably what's going to happen is that you're going to make quality blind decisions, meaning that you're engendering ineffective teachers in classrooms. The other statutes that we challenged were the dismissal statutes. The dismissal statutes because they were, to say the least, Byzantine in terms of their complexity, the number of steps, the appeals, the amount of money it cost, et cetera, et cetera. I'll get to some of that evidence in a moment. And we made the point that obviously if you have a dismissal system that effectively precludes the dismissal of teachers, then it's completely illusory. It's not a dismissal system at all. It's essentially an homage to basically an efficacy, because you can't dismiss people. And then we had the LIFO statute. When you have the unfortunate event of layoffs, what are the criteria that you're going to be used in making the decision of who gets laid off? Well, like in Minnesota and California, the only criteria that's prescribed is seniority. And we argued that that, of course, is problematic because, among other things, it would force districts to fire teachers that were actually high performers while retaining those who were not. And so we made the point that both individually and collectively, these statutes placed California public school children at risk of severe harms, and particularly those who were poor and minority students. And I'll explain that in a moment. The judge's decision, some of these slides I'm going to move through quicker than others, essentially found that the plaintiffs had met their burden of proof on all of the claims that had been advanced, that the evidence, I mentioned evidence before, I'll say that again, the evidence that has been elicited in this trial of the specific effect of grossly ineffective teachers on students, the evidence is compelling. Indeed, it shocks the conscience. And it does shock the conscience. And that'll be clear also as we proceed through the presentation. I want to start with, without getting too far in the weeds on some of the legal issues here, some of the pillars on which this suit was based. You have a constitutional right to education in the state of Minnesota. You also have an equal protection clause in your Constitution. In California, we also have a constitutional right to education. Article 9, Section 1, education is essential to the preservation of the rights and liberties of the people. And in Article 1, Section 7, we have a person may not be denied equal protection of the laws. So clearly the constitutional basis was one. We also were fortunate in California to have a very rich history of decisional law in the state, Supreme Court precedents that looked at what it takes, in essence, to have equal educational opportunity and recognized that, among other things, in the Serrano case, that funding was obviously important, that if you have asymmetries in funding, obviously that can wreak havoc on having equal educational opportunity. The Butt decision in California said that time in school was also integral to having equal educational opportunity. That if you had, for example, some people for whatever reason had 6 weeks less in school than other school children, that those people that had the shorter period were operating at a deficit in terms of their education, and that that would violate the Constitution as well. I'm not going to get too much into the legal analysis of it. I just want to flag this point that one of the arguments that we made is that the statutes that we challenged imposed a real and appreciable impact on the student's fundamental right to equal educational opportunity, and indeed the court found that that was the case. Now, the statutory analysis that was used in this case is one called strict scrutiny, where we were able to demonstrate that the state had failed to meet its burden to establish that the education codes that we were challenging had a compelling interest and that they were narrowly tailored to what those interests were. So in other words, we started with the constitutional right to education, which is fundamental, as well as the equal protection right to education, which is fundamental as well. And we were able to demonstrate that the impact of these statutes, which I said engendered ineffective teachers in classrooms and made it difficult, if not impossible, to remove them, that those statutes really did not have a compelling state interest. There was no rational reason, let alone a compelling reason, to inflict those kinds of harms. And there was certainly no evidence that the statutes were narrowly tailored in order to achieve those specific interests. What we were able to demonstrate is that those statutes instead wreaked havoc and substantial harm on children. And I'm going to get into some of the evidence that we did to prove that. So let me give you an overview of some of the witnesses that we had in this case. Because again, I talked about evidence. The wonderful thing about a trial is it affords an opportunity to bring in people from various portions of the education system. We had about 30 witnesses, and obviously the state and the interveners in the form of the teachers union had witnesses as well. But we had superintendents, we had human resource officials, principals, teachers, plaintiffs, and parents. We had a number of experts that I'm going to talk about, as well as the Department of Education. This, I think, is impressive because we had witnesses and deponents that testified in their experiences in about 28 districts in California. And what I think is also impressive is that these districts from which we had these witnesses constituted 22% of the students statewide. That's a very significant number. I mean, obviously, you're not going to have a trial where you have 100% of the students and the teachers come in and testify. But to achieve 22%, that is overwhelming evidence of what it is that you're talking about. I mean, some courts have looked, and some people would look at smaller numbers as being statistically significant. We're talking about 22%. I should note that among the districts that we had was Los Angeles, which happens to be the second largest school district in the country behind New York. So just in California alone, Los Angeles represents about 10% of the students in the state of California. So when you have visibility into what's happening in terms of the impact of these statutes on kids and their education, that's not a microcosm. That's a very significant number. So the evidence that we were able to prove, to be able to elicit, proved the following. And these are some basic building blocks as well. That the ability of a teacher to actually achieve student learning can be assessed and measured. You know what's so interesting about that first point? When I first got involved in this case, I actually thought that that would be sort of the most elementary, least challenged question. Why would we even have an issue with respect to this? Shouldn't we have a stipulation that that's the case? Of course you can measure a teacher's impact on student learning. And of course it can be assessed. We assess dentists, doctors, plumbers, sports figures. I mean, the list goes on and on. How many sectors of society do we actually purport to say, you know, what they do is immeasurable? We got to give up. It's hard stuff. Impenetrable. We can't do it. We do it all the time, and certainly it can be done here. The other tenet, that there are ineffective and grossly ineffective teachers in California school districts. We were able to get evidence from our witnesses as well as from the defense witnesses that that was the case, and indeed that they could be identified. That the disparity between effective and ineffective teachers in California is substantial, and that students taught by grossly ineffective teachers fall behind their peers significantly, and that grossly ineffective teachers can cause substantial harm that impairs a student's life. We proved these things in part to be able to demonstrate why this constitutional right to equal educational opportunity is so important. Why it is so important that you have a proper balance between protecting the interests of students and teachers. Because students matter, but teachers matter also. And that if you have a focus, a myopic focus on the education code and on schools, strictly focusing on the interest of job preservation, without regard to what's in the best interest of children, you are doing a disservice and not fulfilling the fundamental premise of public education, which in this country, one of the great things that it's done traditionally and that it can do is not only close the achievement gap, but close opportunity gaps, and also close other gaps, like racial divides, cultural divides, enormous things that even if your home life or something else has failed you in terms of getting you equipped to participate in this democracy, that perhaps the place that you could go that would be a stabilizing influence and that would give you a shot at having an opportunity to be part of the talent pool in this society is a public school education. And if you fail people in that dimension because your focus is somehow mired in issues other than what's in the best interest of these kids, it not only violates the Constitution, it does a disservice to the society as a whole. That's why it was important to delineate and to prove each one of these points. So one of the things that we did by bringing in professors, and we had experts, Dr. Chetty from Harvard, we had Dr. Thomas Kane from Harvard as well. Dr. Thomas Kane is one of the proponents of the MET study, which was done by the Gates Foundation, which looked into issues about measuring teacher impact on students, is that we thought it would be interesting to have testimony about what would happen if you replaced the bottom 5% of teachers with average teachers. We're not talking about stratospherically amazing teachers, but average teachers in terms of the benefit on students. And the answer is this, that by replacing the bottom 5% of teachers with average teachers, it amounts to $50,000 in lifetime earnings per child. And in a classroom of 28 students, that's $1.4 million. The other thing that we were able to demonstrate is that the disparities in terms of months of learning lost by having a teacher that was in the bottom 5th percentile versus a median teacher in the Los Angeles Unified School District in both English and in math were actually worse. In other words, more months of learning lost in LAUSD than in other major metropolitan areas like New York, Memphis, Hillsborough County, Dallas, and Denver. This is Dr. Thomas Kane, again, his study, The Measures of Effective Teaching Project, and the basic tenet there being that it's possible to implement systematic and replicable measures of teacher effectiveness. One of the other things that he did, because some people, when they sort of criticize this notion of being able to assess and identify and measure teacher impact on students, is they say, oh, well, you're talking about standardized tests. Each expert that we brought to the stand dealt with what I would call a phobia of using standardized test scores for any purpose by explaining, and it's right here on the slides, schools can use multiple measures to identify effective and ineffective teachers, including but not limited to standardized tests, which means that they can use surveys, they can use observations. What is not a good idea is to completely disregard objective evidence of learning. Because then what you're doing is you're making assessments about teachers in their jobs based on impressionism. I went to the class, I saw the teacher, they looked like a teacher. Okay, well, that's maybe a constituent element of this. What was their impact on that class? Did those students learn? And again, it's not some rigid sort of absolute sense that's a metric of how much someone learned. It can be relative, and it can be calibrated to the particular teacher in a given instance. Where if someone gets a class, let's say, of people that are 2 years behind in learning, and let's say that they happen to achieve at the end of that year 1 year of learning, they don't completely close the gap, well, guess what? That 1 year is progress. So the notion that, let's not use objective evidence because it can be used in a really inimical way, I mean, I think it, number one, disregards the fact that with value-added methodologies and other studies that look at academic growth over time, you can control for factors that are so-called exogenous factors. In other words, factors extrinsic to the school environment, like poverty and home environment, et cetera. You can take that into account, and you can isolate those factors to specifically focus on the impact that a given teacher had on those students. The bottom line is the science is there, we should use it. So I'm going to go through some, not all, of the arguments that we heard in the trial and what the response was. One of them was, and I just mentioned this, factors other than teachers impact student achievement. And I'm going to simplify the response. Whatever the impact of the other factors are, there can be no dispute about the importance of teachers. And to me, I was talking about this earlier, it's sort of the hegemony of the false idea, right? Why does there have to be a choice between addressing one ill versus another ill? Why is it mutually exclusive? Why can't we address all ills? But while we're focusing in a courtroom on this particular issue of these statutes, let's deal with that. Another argument that we had is that teachers only impact in-school academic success and their effects fade out over time. But the evidence that we showed was that teachers actually impact long-term student outcomes. Where you go to college, teenage pregnancy, whether you're incarcerated, what neighborhood you live in, what kind of job you have. The evidence is out there that it's not just a short-term impact, but a long-term impact. There was an argument that only a small number of teachers are grossly ineffective. However, students taught by grossly ineffective teachers receive an education far below statewide standards. And in our trial, we were actually able to get an admission from one of the defense's expert witnesses. This was a recurring theme, by the way. During my closing, I actually made a point that we could actually engage in an exercise of whose witness was it anyway. And we would be able to demonstrate that some of the best evidence that we had in the case came out of the mouths of the experts called by the teachers union as well as the state of California. Why? And the reason is very simple, because we were eliciting fact. And as I said, this is not about making a speech. This is about someone asking pointed questions, faced with evidence, and having to speak under oath, truthfully. And when that happens, there's a lot of separation from, again, hyperbole and argument, and you're getting down to where the rubber meets the road. And on something like this, we were actually able to elicit testimony that, well, let's say that there's 1% to 3% of the teachers in the state of California that are grossly ineffective. There's 275,000 teachers per annum in California. So 3%, over 8,000 teachers. Now, if you take an average tenure in terms of being a teacher, and let's say that it's 20 years, and you assume that they have 25 kids per class, again, both modest numbers, You're talking tens, if not hundreds of thousands of people that are affected. And I always look at that when people try to be dismissive and sort of small mind the numbers and say, well, it's really not that bad. I say, okay, so are you going to pick which kid gets deprived of a quality education? Tell you what, let's take a look at the hundreds of thousands of kids that are potential candidates. You point out which one is not going to get a chance in life because you thought it was okay to perpetuate this. Which one? The decision's being made unconsciously every day, by the way, to the extent that there's inertia in changing statutes that are self-inflicted harms that we could address right now. Whether people are aware of it or not, they're marginalizing and harming kids. You know, I've made this point before, that if someone got up in polite society and said, I'm running for office on a particular platform, and the platform includes disenfranchising minorities and making sure that they don't get a chance to achieve. And let's make sure that poor people also, that they stay in a cycle of poverty. People would say, oh my God, that's horrible. I can't believe that you said that. I mean, you know, hopefully you get no votes with respect to that. Well, that's if someone actually said that explicitly. But by having statutes that effectively inflict the same harm, by guaranteeing that you have an achievement gap and an asymmetrical distribution of quality teachers, you're doing the same thing. That's the ugly little truth. Overt racism, not politically correct. Overt classism, not politically correct. Doing nothing, maintaining the status quo while those harms are visited on people, I don't know how that gets a pass. But fortunately, it doesn't when you have litigation like this that challenges those statutes. One more point about why a courtroom. Some people say, well, wait, why would you go to a courtroom? Why not let the legislature resolve this? Well, I didn't even have to complete that thought. But let me just say this about a judicial decision. You know, one of the things that made me inspired to be a lawyer, in this, my hero when I grew up, in addition to whatever other heroes I had, one of them was Thurgood Marshall. He was the first African-American justice on the Supreme Court. He also argued Boundary Board of Education. I thought how amazing it was. I was probably 8 years old. My parents bought me a book about the civil rights movement and Thurgood Marshall, and I remember reading it. And I remember just fixating on him, how transformative he was. Here's a guy who wasn't even allowed to go to the law school of his choice, who ended up being a Supreme Court justice, and he ends up being on the Supreme Court. Tremendous story of perseverance, obviously a testament to how the possibility of change in America is not just a possibility, but a reality. But it reminded me that there are vicissitudes in politics. Legislators come, they go. Laws change, they can change in different directions. But the beauty of a case is that once a ruling is handed down that says these statutes are unconstitutional, they violate the equal protection, they violate people's right to equal educational opportunity, that's written with indelible ink. Doesn't matter who's elected, doesn't matter what party they're involved in, that becomes the conscience and the reminder of the society that there is a constitution and you cannot go below that standard no matter who's in power and no matter who's purportedly calling the shots. The other point is judges call balls and strikes on what's constitutional, not the legislature. The beauty of our system is the checks and balances system. Can you imagine if we relied on the legislature to be self-correcting historically? In other words, if we had still segregation in schools and there had not been an avenue to challenge that in courts and we just waited for the legislature to get that right. You know what you could have? You could have a tyranny of the majority and an annihilation of the rights of the minority, which is one of the reasons why in this country people have resorted to courts knowing that no matter what's happening in the majority, that as a minority, maybe even the most disenfranchised minority, maybe someone who doesn't have a lobbyist, maybe someone who can't vote, i.e. a child, that they still have constitutional rights that can be vindicated. So we talked about the monetary effect of grossly ineffective teachers. We're talking about, as I said, 8,250 grossly ineffective teachers, rough calculation, over 200,000 students being harmed. We were able to produce evidence at trial that the net result of these grossly ineffective teachers, $11.6 billion in lifetime earnings lost per year, and that's just in California. I mean, in other words, you can't sort of sublimate the harm and say, well, you know, this is an abstract concept and it's up for debate. No, they actually went in, did copious studies of the trajectory of different students over long periods of time, and were able to actually track with fairly granular detail where those people were living, what they were doing, how much money they were making, etc. And indeed, it does shock the conscience. So I talked about this before, and this is the permanent employment statute that forces districts to make premature decisions about who should be given tenure. I mentioned that it's in fact not 2 years, that it's 16 months. And in the interest of time, I'm just going to sort of go down to the net result, which is that the evidence showed that grossly ineffective teachers obtained permanent employment and that a longer period would result in fewer errors. We had experts admit, again from the defense, in a couple of instances, that 5 years would actually be a better period. Now remember, we didn't call these people to the stand. They were called by the people who were the state and who were the teachers union, and they admitted that. And I need to underscore something. The time is not dispositive here. In other words, if someone says, oh, well, all you're really talking about is extending the period. No. It's also making sure that the decisions about whether someone gets permanent employment are based on performance. Because clearly the connection of time with a performance-based assessment is that you actually have time to do two things at least: collect data and synthesize and process data. So it's not just some magical number like, oh, I see, so the Constitution is assuaged if you just flip it to 4 years. You're kind of missing the point, and that's why I needed to hammer that to make sure that that's clear, that it's also a focus on performance as well. I'm just going to go through some of this. Some of the arguments we heard about this is, well, what's wrong with having the tenure period the way that it is? If a district has doubt, it can simply deny tenure anytime they have doubts about the teacher. Well, we elicited testimony that districts have doubts about most teachers after only 16 months, and why wouldn't they? If you think about it, it's just common sense. One of the arguments we heard is that districts can avoid problems by improving their hiring practices. So one of the narratives in the trial from the defense was, these laws are fine. The problem lies with the school districts. You know, they're not working well. They're not efficient. For instance, if a principal wanted to, they could just spend more time on tenure decisions. And we elicited testimony from some of the tenures and principals along the lines of, and I'm being somewhat facetious here because it wasn't quite like this, but so Principal X, you have unlimited hours, of course, to devote to tenure, right? In other words, you have more than other people, 24 hours, 7 days a week. You have an extra reserve of hours to do all of the other tasks that you have to do. And the answer is, of course not. And we got these principals to give a day in the life in terms of how many different responsibilities they have, and that no matter how you try to divide all those responsibilities into 16 months, the math just doesn't work out. It's not a, you're inefficient. It's, this is imposing a constraint that doesn't make any sense. So I want to move to dismissal. So this was a graphic that we used to demonstrate the dismissal process. I'm just going to get some of my water here. And as you can see, it's rather lengthy. One of the things to note is that before you even get to the point of having a notice of unsatisfactory performance or a notice of unsatisfactory conduct is the extensive observation period that builds up into the dismissal process. And then, of course, you have the preliminary dismissal charges, and then you have this next step, and as you can see, it flows, and you also have the possibility of judicial review in your state to the possibility of multiple appeals, including up to, obviously, the Superior Court and the Court of Appeal, et cetera. And this is what we submitted was illusory as far as really saying that you could dismiss people, because we demonstrated that it takes years to dismiss a grossly ineffective teacher. The evidence that we elicited is that it could take anywhere to 4 to 5 years to dismiss one teacher, and that it could cost hundreds of thousands of dollars. We elicited testimony that it could cost $400,000 to $500,000, and in fact, we had an instance where the effort to dismiss a teacher took a decade and cost 7 figures. Now, in California, there's something called a Commission on Professional Competence that makes the decision at the outset about whether or not the teacher should be dismissed. And the standard, unfortunately, is essentially that that person is incapable of remediation. I mean, that's the custom and practice. It's not actually enshrined in the statute, but the testimony that we had is that that's sort of the threshold. Like, in other words, you can't reform this person. That's a pretty high threshold, if you think about it. Imagine the documentation and the paperwork, et cetera, that goes into that. The net result being that California districts rarely seek to dismiss, and this is the deterrent effect of having a cumbersome dismissal statute, except in extreme cases. And again, the testimony we elicited was, and there is a direct correlation here, that if this were a leaner, more efficient system, they would seek to dismiss more ineffective teachers. So using those concepts in an algebraic way, A and B and C, what's C? C is if you change the laws, you would have more ineffective teachers exit, and currently that you don't do that, you have more of them, which means harms to kids. So this was something that we wanted to elicit. And again, what I love about being a trial lawyer and the ability to create images, also to be able to kind of capture things, really reduce them. You can have a lot of argument with lawyers about these statutes, right? You know, do they work, don't they work? Well, we have workarounds. You know, we have things like we can settle with teachers. We don't even have to go through this onerous dismissal process. And one of the things that I was fascinated about is, I said, am I the only one catching the logic here, being sort of tortured on its own pillar? This idea that I'm going to defend a dismissal statute by saying it's so great that you don't have to use it? You're boasting about the fact that you work around the statute where you still have to pay ineffective people money to leave as an inducement? Wouldn't that money be better used to educate children? Wouldn't you rather have a system where, as opposed to having to meet with people and induce them and coax them to leave with a generous package, even if they aren't doing their job, you could simply dismiss them? Wouldn't that be interesting as an alternative? And in the proof is in the pudding moment, there are 275,000 teachers in the state of California. We looked at every decision involving the Commission on Professional Competence over a 10-year period. And we found that there were only 14.7 decisions per year. And out of 275,000 teachers in the state of California, and this, by the way, as a graphic, is 3 Rose Bowls, which would fit 275,000 people. We showed that only 2.2 teachers per year are dismissed for unsatisfactory performance. Not 2.2%, 2.2. Let's round down, 2. Why quibble? Let's just make it 2. 2 teachers per year. Now, you don't have to be a legal scholar or a mathematician to figure out that a system that has 275,000 that only allows 2 to exit a year is a broken system. And so when you do that with any dismissal system, and you really get down to the numbers, you say, you know what? You can say whatever you want to. That's indefensible. That doesn't work. That's illogical, and people are being harmed. So some of the arguments that we heard is, again, like I said, we talked about the workarounds. We talked about how that still costs time and money. We also talked about the fact that, well, that's aspirational because not all grossly ineffective teachers are willing to go. And so at some point, you're going to have to deal with these dismissal statutes. And you're going to have to pay that money and go that distance. And why should you have to do that? Now, one of the things, and I'm going to preview this, is this concept that we got where people said, well, if you're talking about attacking dismissal statutes, You're trying to destroy due process. And again, I said, well, this is a great opportunity. This is what I call a teaching moment, because we can actually talk about what due process means. It doesn't mean that 17-step process. Neither the framers of the Constitution or the legislatures that brought about that process in California were saying due process requires that labyrinth. All due process requires is a notice and an opportunity to be heard. Period. And what we did at trial is we adduced evidence of other people that work in public schools that are not certificated teachers. People like custodians, people that perform other functions that are integral. And we said, well, what happens if you want to dismiss those people? They have something called Skelly rights. These are basic rights of notice and an opportunity to be heard. How much time do you think it takes to dismiss those people? 3 or 4 months. How much do you think it costs to dismiss those people? About $3,400. And the judge asked a great question in his ruling, in a rhetorical flourish, which is anyone suggesting that the protections that those people have are not due process? No. And if those protections are due process, why aren't they good enough for teachers? Well, the answer obviously is they are. And what I would tell people when I first got involved in this case, when they would come up to me and start talking about due process, I'd say, wait a second. If you really think that it's constitutionally required that people have this particular form of dismissal protections, let me ask you this question. If it's a constitutional right, why don't we all have it? Do you have that constitutional right on your job? Do you? Do any of you? No. So we can dispense with the notion that this is somehow, an inalienable right that's constitutionally guaranteed. Not this particular form of excessive statutory protection that is anathema to actually dismissing people that should not be teaching kids. There is an alternative to dismissal that strikes a balance between respecting the teacher as you respect other employees in public employment and having an expeditious process to respect the rights of students. So I want to talk about layoffs. We showed that the seniority-based layoffs deprive students of terrific teachers in favor of ineffective teachers, and that conducting layoffs on the basis of seniority imposes harm. One of the demonstrations that we had from a Dr. Raj Chetty was that the impact on students, if you had what we would call an effectiveness-based layoff system, one that allowed you to actually consider the effectiveness of the teacher, would be a gain of about $2.1 million per teacher for a given classroom. Because here's the concept. Those that propose to advance seniority as a metric for making a decision about layoff will say, well, it's great because it eliminates argument. And it's objective. Objective is, and that's what's paramount, is that we want to be objective and we want to eliminate argument. And one of the points that I made was, so is the ability to dunk a basketball. And so is height. So why don't you just dismiss teachers on the basis of height? If your rationale is you want objectivity. Because that has about as much correlation to whether someone's effective as seniority. You cannot ipso facto proclaim that all teachers who've taught longer are better than teachers who have taught less. That is counterfactual, and it just basically defies common sense. I want you to think about something else too. Imagine using that logic of we're going to get rid of the younger people first, or the people that are newer first, and preserve the people that have been there longer for the sole reason that they've been there longer. And let's say that we use that in the tech industry. Where do you think we would be in this country? Well, what if we did that in medicine? Where do you think we would be? Pick any area in society where we said, nope, we're not going to look at how you perform your job, just how long you've been here. How many of you would want to be serviced or cared for in a paradigm like that? And yet, we do it with kids. For no reason. For no valid reason. For no compelling reason. For no constitutional reason. Because you actually can make decisions based on performance. So some of the evidence that we had, and I'll get to this. Let's talk about the disparate impact component, harm to minority and poor kids. This is a pretty compelling part of the case as well, because we had to show, or we wanted to show, how these laws work in terms of their impact on the most disadvantaged in society. And you start with the fact that, and this shouldn't come as a surprise, poor and minority students are more vulnerable to the harms of ineffective teachers, right? I mean, isn't it kind of common sense that there are people that come to class that they don't have tutors, right? If they want to go to college, there's not going to be SAT prep course money available. If they're not getting advanced algebra trigonometry, it's not like, don't worry about it, we're going to let you use the same guy your brother used, and you'll be okay. There's none of that. They may be the only person in the house interested in education. And yet, we take these kids, and they're in these school districts, and what happens? As more effective teachers transfer to more affluent schools, what's left behind is what? Ineffective teachers who, guess what, can't be dismissed, right? And then you get something that in Los Angeles, there was an article about this, is called the dance of the limits. When school districts can't use the statutes to dismiss ineffective teachers, that may not be the end of the analysis, that may be the beginning of the analysis. Because guess what? In some well-heeled areas where parents feel empowered and know this will not happen to my child, is the dialogue, and this person needs to go, somehow that teacher exits that school, and where do you think they end up? They end up in the schools that have the highest needs, highest attrition, and that is often in the black and brown and the low-income schools. And that's why it's called the dance of the lemons. And in addition to that, when it comes to layoffs based on seniority, what happens is that the people that are in the poorest schools, the most challenged schools, end up being the ones that have the highest number of dismissals because they have the highest number of junior teachers, because they have the highest amount of what you call the revolving door and churning. And we had evidence at trial that in some places, there were schools that would lose 90% of their teachers. Or the teachers, 90% of the teachers would get a layoff notice. Now, true, some teachers get hired back, but we also elicited testimony from the teachers of what does it feel like to you when you get a pink slip repeatedly, whether you were teacher of the year or not? Does that boost your morale as being a teacher? No. And one of the other arguments about using seniority was, well, it's great because it encourages teachers to stay in the profession. And we asked those teachers, when you got asked to leave, not because of your performance, but because of your seniority, did that boost your morale? Did it make you want to stay a teacher? Would you have liked to have been assessed based on your performance? I mean, these are common sense answers. But the gravity of this is we're taking kids. And you can't, I don't care how cynical you are, you can't look at these kids and say, we just can't understand why you're just not like our kids. You know, I mean, we just don't understand it. Or it's your fault somehow. This is a child. They don't have fault in terms of why they're in that environment and why they have whatever achievement gap issues that they have. And when you say to those kids that somehow they're written off and that you're then, in addition to allowing the accumulation of these teachers in their schools, to then lose more teachers, you're basically compounding the error. It is highly destabilizing in a learning environment, was the evidence we had at trial, to have massive attrition of teachers. And this did not happen in areas that were affluent or white, not nearly to the same extent. So just think about that. The very people that we want to look to and say, you know, hopefully this generation is the one where we can put to rest these divides. We fashion ourselves in some circles as a post-racial society. Yeah, let's do that. That's great. Let's do that. Okay, so now we got to actually deal with reality, which is, you know where that starts? That starts in closing this gap. But when you take the most challenged people and you ask them to bear the brunt of a broken system that not only accumulates ineffective teachers in disproportionate numbers, but then doesn't allow you to fire them, and then has you remove more of those teachers there than any other place? Really? I mean, that is unfathomable, and that shocks the conscience. So that's why there's this disproportionate impact in this issue. I'm going to move past some of these slides. These slides were basically demonstrating that in Los Angeles Unified School District, African American students were 43% more likely than white students to be taught by a teacher in the bottom 5%. That Hispanic students were 68% more likely than white students to be taught by a teacher in the bottom 5%. This is the 21st century, and we still have these numbers. This is unbelievable. So let me move through what is the end of this and start getting into these slides. So when people say, well, you know, we have a parade of horrible fear that if you change statutes, you know, what's going to happen? The great thing about this country is that the 50 states offer various experiences. So in terms of the time to tenure period, we were able to demonstrate that California is one of only 4 places in the United States where the tenure period is 2 years or less. 32 states, including Minnesota, have a 3-year period. 4 states have a 4-year period. You have 6 states that have a 5-year period. You have 4 areas in the United States where they don't even have tenure. They have annual contracts where people have to come in, and on every year they get assessed in terms of how they did. So there's no reason to believe that somehow the laws of physics or the air in these other states are different, and that somehow they're able to pull off something that may strike a better balance between teacher interests and student interests without there being complete entropy. Well, of course not, because it means that it can be done. This is an example, just to be able to let this seep in a little bit more, of the difference between what are the basic protections that all state employees have versus the protections that teachers have. So that every symbol in red that you see here with a plus is an extra protection that only certificated teachers had that the other state employees did not have. And this is a really good illustration of why all of this stuff, which includes full evidentiary hearings and discovery before someone can be fired, is not a mandate by due process. And I want you to, for non-lawyers, I want you to think about this for a second. In most instances in society, if someone gets fired from their job and they say they thought it was wrongful, they bring a lawsuit. The way these statutes work, it's kind of the other way around. You have to have the lawsuit and actually get permission to fire the teacher with depositions and discovery, et cetera, and appeals, by the way, before you can even make that happen. I mean, it's completely inverted and counter to the way that employment in other contexts works in many different aspects of the state. With respect to LIFO and seniority, we were able to show that in 2 states, seniority can't even be considered. In 20 states, it says that seniority cannot be the sole factor. In 19 states, layoff criteria is left to the discretion of the district, and in 10 states, it must be considered. Now, the reason, again, this is important is when people start talking fearfully about, oh, we can't do that because the sky's going to fall in, just take out a map. Look to other states and say, oh, that's interesting. Look at that. That's fascinating. They actually did exactly what we wanted to do. Let's see how those kids are doing. Let's see how that whole thing is going now that happened. Because again, you know, the truth is a great litmus test for these theories in terms of what actually happens. So again, I've talked about the decision and the court ruled in our favor. These are just some of the snippets of the decision. The court found on the permanent employment statute that the court finds that both the students and teachers are unfairly, unnecessarily, and for no legally cognizable reason, let alone a compelling one, disadvantaged by the current permanent employment statute. As to the dismissal statutes, the court said this court heard no evidence that a classified employee's dismissal process, i.e. a Skelly hearing, violated due process. Why then the need for the current torturous process required by the dismissal statutes for teacher dismissals, which has been decried by both plaintiff and defense witnesses? And finally, with respect to the last in, first out statute, the court said the logic of the state defendant's intervener's position is unfathomable and therefore constitutionally unsupportable. The case is on appeal at this point, and we're very confident about being vindicated on appeal and the case being affirmed on appeal. And again, I wanted to start where I began, by paying our respects to the plaintiffs in the case, who, as I said, some of whom actually testified. Thank you.